Hi, I'm Sean Palmer. Welcome to the Texas Employment Law Vlogcast, hosted by the Palmer Law Firm. This is the first in a series of vlogcasts educating the public on employment law in Texas. This vlogcast is for general education purposes only and should not be a substitute for seeking the advice of a professional attorney who can advise you on the specifics of your case. If you need more information, please contact my law firm. Let's begin. Although the employment relationship was once considered to be a contractual relationship determinable only on a reasonable notice and at-law employment rule, subject to narrow exception, it has been firmly entrenched in Texas law for more than 100 years. However, at-will employment does not preclude employers and employees from forming subsequent contracts so long as neither party relies on continued employment as the condition for the contract. The general rule in Texas, as in most American jurisdictions, is that absent a specific agreement to the contrary, employment may be terminated by the employer or the employee at will for good cause, bad cause, or no cause at all. It has also been said that an at-will employee is subject to discharge for any reason unless prohibited by Texas or federal law. Put another way, under the at-will employment doctrine, an employer may generally terminate an at-will employee without fear of legal repercussions for a good reason, a bad reason, or no reason at all. Exceptions to the general applicability of the at-will employment doctrine include terminations based on unlawful discrimination and retaliatory terminations that violate the Texas Whistleblower Act. Essentially, this means that employees are deemed to be employed at the will of their employers unless they are protected by a discrimination statute, a specific retaliation statute, an employment contract, or common law contract, or tort principle. Generally, there are a number of Texas statutes that prohibit retaliation against employees, including those that prohibit employees from retaliation for the employee filing a workers' compensation claim, retaliation from the employee's union membership or non-membership, retaliation for the employee's jury service, retaliation for the employee's service in the military, retaliation for employees' failure to pay child support, and retaliation for the employees reporting violations of the law. The Texas Supreme Court also has held that an employer may not retaliate against an employee because the employee refused to perform an illegal act that would subject the employee to criminal liability. The common law exception to the employment at-will doctrine that an employer cannot fire an employee for the sole reason of refusing to perform an illegal act was created to promote the public policy of preventing an employee from being forced to choose between keeping his or her job and facing criminal liability. In Texas, employees must find other grounds for redress if they believe that they have been discharged or otherwise treated unfairly. For that reason, discrimination claims and common law claims that are recognized in the employment context have taken on added importance. Employment law has become an extremely active area of the law. It has also become extraordinarily complicated. The roots of all this activity are not difficult to understand. Employees are greatly concerned, particularly in the present era of economic uncertainty, about job security and protection of their rights. On the other hand, employers face a multitude of issues in the changing landscape as well, and they are both economic and legal in nature. They concern such things as the responsibility to provide certain benefits, reductions in force, and the desire to make personnel moves that take advantage of the expanding pools of eligible applicants. These competing interests may create conflict between employees and employers. As a result, the development, interpretation, and interplay of the Texas and federal schemes has become more mature and more complex with the passage of time. Discrimination claims arise when an applicant or an employee claims to be the victim of unfair treatment or harassment because of membership in one of protected categories. The federal and state statutory schemes protect against employment discrimination based on age, sex, including pregnancy, but not generally sexual orientation, race, color, national origin, religion, creed, disability, marital status, criminal history, uniformed service status, or engaging in lawful activities. Some municipalities also have specific anti-discrimination laws where the employer reacts adversely or retaliates against a person raising a discrimination claim. The employer may be liable for retaliation even if the original discrimination claim fails. The explosion in the number of discrimination cases and the difficulties that can be encountered in resolving them underscore the importance of good communication between employer and employee, including frankness in evaluating performance deficiencies. The purpose is to avoid surprises and lawsuits. The employment relationship is governed by contract, if applicable or not, by federal, state, and local statutes and regulations, as well as case law. In some instances, constitutional mandates must also be considered by the practitioner representing a party to an employment dispute. The rights and obligations of participants in the employment relationship are derived from constitutional, statutory, and regulatory mandates requiring non-discrimination, fairness, or safety, common law principles applicable to contracts and tort negligence liability, administrative interpretations of the anti-discrimination laws. The interplay of the state and federal schemes in employment law is generally subject to the doctrine of preemption. Although in many areas, such as discrimination, the laws work largely in tandem, and preemption issues often do not arise. For example, the expansive preemption provision of ERISA are intended to ensure that employee benefit plan regulation is exclusively a federal concern. Because ERISA is deemed to be comprehensive with regard to the remedies provided and excluded, any state law cause of action that duplicates, supplements, or supplants the ERISA civil enforcement remedy conflicts with the congressional intent to make the ERISA remedy exclusive and is preempted. ERISA includes expansive preemption provisions, which are intended to ensure that the regulation of employee benefit plans be exclusively a federal concern. For many years, employer discretion has also been limited by certain federal and state statutes establishing minimum standards for certain aspects of the employment relationship. Federal statutes follow: the Federal Labor Standards Act, FLSA, enacted in 1938, limiting employment of children and requiring minimum wage and overtime pay at 1.5 times the regular rate of pay for hours over 40 in 1 week worked by covered employees in covered industries. The Family Medical Leave Act, FMLA, enacted in 1993, requiring covered employers to provide a maximum of 12 weeks of unpaid leave for specified medical and family purposes to employees who have worked at least 1 year and 1,250 hours within the previous 12-month period at a worksite where the employer employs 50 or more employees within a 75-mile radius of that worksite. Worker Adjustment and Retraining Notification Act, requiring that covered employers provide 60 days advance notice of mass layoffs and plant closures, as defined in the Act, affecting 50 or more employees during any 30-day period. Immigration Reform and Control Act of 1986, prohibiting employers from knowingly hiring, recruiting, or referring unauthorized aliens or employing persons without proper employment eligibility verification, and also prohibiting employers from discriminating against applicants or employees based on national origin or citizenship. Occupational Safety and Health Act, OSHA, requiring covered employers to undertake broad obligations to assure a safe workplace and authorizing the Occupational Safety and Health Administration of the U.S. Department of Labor to issue comprehensive regulations over workplace safety. Employee Retirement Income Security Act of 1974, ERISA, creating a preemptive federal law governing employer obligations with respect to pension and welfare benefit plans. Employee Polygraph Protection Act, enacted in 1988, generally prohibiting private employers from using lie detector tests for pre-employment screening, except in some security and pharmaceutical businesses, or during employment except in limited circumstances involving an ongoing theft investigation. Federal statutes that prohibit employment discrimination, including the following. Title VII of the 1964 Civil Rights Act, prohibiting classifications or adverse employment actions based on race, color, national origin, sex, or religious preference. Age Discrimination in Employment Act of 1967, originally prohibiting employment discrimination based on age between 40 and 65, and now prohibiting age discrimination against all those over 40, with limited exceptions, and requiring that enforceable settlements of federal age discrimination claims conform to specific statutory standards provided in the Older Workers Benefit Protection Act. American with Disabilities Act, ADA, enacted in 1990, prohibiting discrimination against those who are mentally or physically disabled, or who are so perceived, or who have a record of such disability, and requiring reasonable accommodation where this would permit such persons to perform the essential functions of their jobs. Rehabilitation Act, providing increased employment of persons with disabilities through implementation of statewide workforce investment systems. Equal Pay Act of 1963, providing equal pay for men and women performing equal work. The Civil Rights Act of 1866, providing all persons of different race, ancestry, or ethnic characteristics the same rights as white citizens to enforce contracts and to equal benefits of the law, enforceable by lawsuits, including jury trials. Title IX of the Educational Amendments of 1972, providing that no one should be excluded on the basis of sex from participating in any educational program or activity receiving federal funds. The Civil Rights Act of 1871, a counterpart to 42 U.S.C.A. 1981, prohibits conspiracy to violate civil rights, including preventing officer from performing duties, obstructing justice, intimidating witness, intimidating parties or juror, and depriving persons of rights of privilege or privileges. Civil Rights Act of 1991, providing for the application of the Civil Rights Act of 1964 to the House and legislative branches of government. Executive Order 11246, providing for non-discriminatory employment practices in the executive branch of government. Immigration Reform and Control Act of 1986, making employment of unauthorized aliens illegal. Uniformed Services Employment and Reemployment Rights Act, prohibiting discrimination against persons because of their service in the uniformed services. Family and Medical Leave Act, FMLA, entitling employees to take reasonable leave for medical reasons for the birth or adoption of a child and for the care of a child, spouse, or parent who has had a serious health condition. Employee Polygraph Protection Act, making it unlawful for an employer to require an employee or prospective employee to submit to a polygraph test. Occupational Safety and Health Act, OSHA, providing for the development and promulgation of occupational health and safety standards. Texas statutes that prohibit employment discrimination include Texas Commission on Human Rights Act, Texas Workers' Compensation Act, Persons with Mental Retardation Act, Disability Discrimination Law, Public Employment Equal Pay Law, Whistleblower Law, Public Servant Sexual Harassment Law, Several cities in Texas, including Fort Worth, Austin, Houston, and Dallas, have passed ordinances banning discrimination based on real or perceived sexual orientation. The administrative agencies handling employment discrimination claims are the Federal Equal Employment Opportunity Commission and the Texas Commission on Human Rights. On a local level, for example, Austin, such issues may also be handled by a municipal agency such as the Austin Human Rights Commission. The EEOC issues policy statements known as guidances containing its interpretations of the law. The EEOC contains a website which contains its most recent interpretations and guidances. The Texas Commission on Human Rights publishes a law notebook, updated annually, containing TCHR's regulations, attorney general opinions, administrative directives, interpretive memoranda, and a jurisdictional and procedural issues paper published by the Commission's Office of General Counsel. There are regulations addressing both the EEOC procedure and the Commission of Human Rights Act. The EEOC regulations are found in the Code of Federal Regulations, and the TCHR's regulations are contained in the Texas Administrative Code. Statutes and regulations also play an important role in wages and benefits, health, safety, fitness to work, and worker privacy. They also offer protection from being discharged for engaging in particular activities. Such wage and hours issues as overtime pay and what work is permitted for minors are regulated by federal and state labor laws, including the Federal Labor Standards Act and the Texas Labor Code. Workers who suffer work-related injuries may be protected under both the state workers' compensation and disability laws as well as the Federal Family and Leave Act and the Americans with Disabilities Act. The Federal Consolidated Omnibus Budget Reconciliation Act, COBRA, requires access to continuation coverage of health benefits when employment terminates. The Federal Worker Adjustment and Retraining Notification Act, or WARN, requires special notices in some cases of mass layoffs or plant closing. In sum, wages and benefits are governed by federal statutes, including the following: the Family and Medical Leave Act, the Fair Labor Standards Act, Consolidated Omnibus Budget Reconciliation Act, Employee Retirement and Income Security Act, Unemployment Compensation Act, Workers' Compensation Act, Texas Minimum Wage Act, Texas Payday Act. The Federal Occupational Safety and Health Act, OSHA, governs workplace safety and deals with both traditional and current issues such as repetitive stress injuries. In addition, the ADA requires work-related accommodations for qualifying employees. Tip: the regulations promulgated under the Federal Occupational Safety and Health Act neither create an implied cause of action nor establish negligence per se. Another tip: a willful violation of the Federal Occupational Safety and Health Act is one committed voluntarily with either intentional disregard of or plain indifference to OSHA requirements, and willful means action taken knowledgeably by a person subject to the statutory provisions in disregard of the action's legality. Willfulness does not indicate bad purpose or evil motive to commit a particular act. However, there must be evidence of that extra ingredient needed for willfulness, either the element of intentional disregard or plain indifference. There are also state rules concerning workplace safety as well as right-to-know laws. While there is no general state anti-smoking law, smoking is prohibited in certain public facilities. The Federal Polygraph Protection Act governs whether an employer can give a polygraph test. There are state laws concerning polygraph testing of certain public employees. There are also state and federal prohibitions against eavesdropping. The Federal False Claims Act protects whistleblowing employees who help the federal government recoup damages for abuses. Although Texas recognizes only a narrow common law public policy exception to the at-will employment doctrine, it has enacted statutes that prohibit employers from discharging employees for reasons that contravene public policy. State statutes protect employees from discharging or other penalties for certain other conduct, including complaining of discrimination, jury service, testifying as a witness in a certain proceedings, filing workers' compensation claims, having filed workers' compensation claims in the past or having complained about violations of those laws, complaining of violations of wage and hour laws or anti-discrimination laws, whistleblowing in the public sector, engaging in military service. Public employees who are covered by the protections that apply to the private sector may also enjoy additional protections, such as a due process hearing prior to termination. Unlike the administrative remedies available for discrimination claims, common law claims are always state law claims addressed in either state or federal lawsuits. Because these claims are often asserted to substitute for the lack of wrongful discharge cause of actions in Texas, the courts will closely scrutinize them to make sure that all elements are present. Employees may not avoid the at-will rule by bringing a tort claim instead. The employer, of course, may assert defenses to such claims, some of which rely on common law principles themselves. For example, the employer may assert a privilege, as the privilege of a supervisor to make certain statements about an employee without being liable in defamation to that employee. The best protection from discharge available to an employee in Texas is an employment contract. An express employment contract provides protection from discharge if it explicitly limits the employer's right to discharge at will. As a practical matter, however, outside of the union context, few employees are in a position to negotiate an employment contract. An employment contract can also be implied. To show that an implied contract exists, the employee must show that the employer expressly intended to limit his or her right to discharge at will through the totality of circumstances, including, for example, by statement in a handbook, an employment application, an officer of employment, or by some other document or conduct. Cases allowing recovery of an implied contract claim are rare in Texas, and those cases in which such recovery has occurred has been limited to their facts and has not signaled any greater encroachment on Texas's at-will employment rules. Some of the most significant employment claims in Texas are not found in any statute, but instead have their genesis in tort law. Common tort claims include defamation, intentional infliction of emotional harm, tortious interference with contract or business relations, negligent misinterpretation, negligent hire, retention, false arrest, imprisonment, assault, and battery. From the outset, federal and state courts have struggled with the absence of clear statutory definitions as to what is prescribed and how unlawful employment discrimination is to be proven. The law in this area is still developing, but certain features are particularly significant. In most employment discrimination cases, the plaintiff employee has no direct evidence whether the employer intended to discriminate unlawfully, and the defendant employer has the best access to the reasons that prompted its decision to discharge, reject, discipline, or refuse to promote the plaintiff. For plaintiffs, therefore, the problem is usually how to prove defendant's intent indirectly through circumstantial evidence. For the defendant employer, the problem is usually how to demonstrate that supervisory actions or personnel practices and their cumulative results were motivated by and are explainable by factors other than unlawful discrimination. The judge-made solution to these problems has been to divide the responsibility for producing evidence between the plaintiff and the defendant employer in disparate treatment cases involving alleged intentional discrimination, while leaving the ultimate burden of proving intentional discrimination on the plaintiff. This is the so-called McDonnell-Douglas shifting burdens approach. For example, to prove discrimination under the Texas Commission on Human Rights Act based on disparate discipline, the disciplined and undisciplined employees' conduct must be comparably serious. Somewhat different evidentiary burdens are utilized in disparate impact cases where apparently neutral employment practices are claimed to have a discriminatory impact on groups of individuals identifiable by minority, gender, or other factors. In the context of a race discrimination claim, disparate treatment refers to deliberate discrimination in terms of conditions of employment, whereas disparate impact claims do not require proof of intent to discriminate. Class actions may be appropriate vehicle to enforce the anti-discriminatory provisions of Title 7, and similar state laws if the employee plaintiffs can satisfy the requirements for maintaining a class action. Class actions up the ante in employment litigation because they expand the number of individuals eligible for monetary relief, may lead to injunctive relief or consent decrees imposing across-the-board changes in personnel policies, and are usually costly in legal expenses compared with litigation of individual claims. Equal employment claims and wage and hour claims routinely include claims for payment of plaintiffs' reasonable attorney's fees and costs, as authorized by the relevant federal and state statutes. Attorney's fee claims significantly increase the employer's potential liability and may thus affect settlement decisions. Fee claims may also create additional issues to be litigated, including whether plaintiff has prevailed, particularly where plaintiff prevails on some claims and not on others, and also whether the attorney's fees sought by plaintiff are reasonable. In addition to their anti-discrimination provisions, both Title VII and state anti-discrimination laws require employers to make reasonable accommodations for an applicant's or employees' religious preferences. This reasonable accommodation requirement was carried over into the Federal Rehabilitation Act of 1973 and into the Americans with Disabilities Act of 1990. The reasonable accommodations mandate can also be discerned in the Federal Family and Medical Leave Act, which requires a covered employer to provide leaves of absence to employees when requested because of pregnancy or other specified conditions. This extension of the non-discrimination obligation from an equal treatment ethic to a mandate for reasonable accommodation of individual conditions has had a significant impact on employer discretion. This concludes the first part of our vlogcast on Texas employment law. Please look for the second in the series.